Hello, and welcome to the cross-examination section of the ULV Justice Center website. Glad to have you. Before we begin, please be advised the information on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Let's go over where we are in the trial process. At the end of each direct examination of a witness, the opposing party will have the opportunity to ask the witness questions about their testimony. Cross-examination is used by the opposing party to create doubt around the witness's credibility and/or their testimony. After all witnesses have been called, the court will move to closing arguments. The purpose of cross-examination is to discredit the witness's testimony and/or credibility. Cross-examination allows the opposing side an opportunity to poke holes in the testimony given by the witness and create doubt around the truthfulness of their answers. If cross-examination does not take place, the opposing party would not have an opportunity to challenge the credibility of the witness. Cross-examination can either change the opinion of the judge and jury towards the witness or affirm their belief in the witness's original testimony. It depends on how effective you are at it. Now let's discuss what needs to be accomplished during this step. Cross-examination is limited to what was brought up in the witness's testimony. The cross-examiner is allowed to ask what are called leading questions in order to test the credibility of what the witness said. That means you give the witness the answer you're looking for in your question. These questions would typically have a yes or no answer. You should only ask close-ended leading questions during cross-examination. This is your time to present your case. Do not allow the witness to tell a story or perform. Let's go over what a leading question is. A leading question suggests to the witness what the correct answer should be. For example, the following questions would be considered leading questions. Your boss is John Smith, is that correct? You had lunch with Mr. Smith on April 30th, 2020 at the Cherry Cafe? Is it true that Mr. Smith called you to tell you that he would be late? During cross-examination, you will be questioning the opposing party's witness. Before trial begins, you will receive a witness list from the opposing party. Your job is to never ask a question you don't already know the answer to. Go over the witness list, review any documents, messages, memories, events, or transactions that involve this person and write them down. Write out the answers they should give based on the evidence you have of their involvement. Use your evidence to contradict their testimony if they do not tell the truth. If they tell the truth, you don't need to repeat it. It is important to bring up only one fact per question. Now, we will discuss what happens next. After each party has had an opportunity to cross-examine each other's witnesses, the trial will move to closing arguments. The closing argument takes place at the end of trial, and the plaintiff typically goes first. This is an important step during trial because it allows each party the opportunity to summarize their evidence, point out discrepancies in their testimony, and argue why the law is in their favor. Both parties are only allowed to reference evidence and testimony that was presented to the court during trial. This has been an overview of the cross-examination section of law. On behalf of the ULV Justice Center, we thank you for your time and hope this information is helpful in your legal matter.